Hey, everybody. Happy Wednesday. Welcome. Welcome to True Crime Wednesday. I'm your host, Lori Hellis. I'm a retired criminal attorney, and we on Wednesdays talk about all things true crime. However, I would be remiss if I didn't point out that we have, why do I always get this wrong? It's backwards. Is why uh, that we have in the background my book on the Vallow Daybell case. It is out in bookstores and available from your local bookseller as well as all major outlets. Um, Hi, I missed you last week, although I have to admit my heart wasn't in it. I know we try very hard not to get political here, but the outcome of the election was very disappointing for me for many reasons. So I needed some time to think and to process that. Speaking of my book, I do have a couple of exciting things coming up. I have just found out that I have been invited to the Tucson Festival of Books in March of next year. For those of you who don't know, the Tucson Festival of Books is kind of a big deal. So it was super exciting to be invited to appear in some panel discussions on true crime topics in their crime for their true crime division. So that was super exciting. I'm also going to do a book signing at Paulina Springs Book in Sisters, Oregon, for anybody who might be visiting Central Oregon. That'll be on December 5th. Sisters is a very popular place for people to go pre-Christmas. It's a darling little town that has been the main street has been has storefronts that have a Western theme, and there's often snow, and it really is a great place. Lots of folks like to go to Sisters pre-Christmas. I am still sending out book plates for anybody who emails me and asks me for a book plate for their book. So if you would like me to sign a book plate for you, drop me an email with your address. That address doesn't go anywhere but into my email file, and I will drop you some stickers and a book plate. And I want to say thank you to all the folks who have posted reviews. There are currently 71 reviews on Amazon, which is awesome because that begins to get us into their algorithm where the book starts being recommended to people who previously ordered other true crime titles, and 109 on Goodreads. So thank you so much if you have posted reviews. If you haven't, please do, because they really help me. So that's all the book news I have. And there are a lot of cases, all of which have a little bit of news. I'm going to save Karen Reed, who had a motion hearing this week, and Delphi toward the end so that we can kind of dive a little deeper into those. But before I do that, there are a bunch of cases that we've been following that have developments in them, even if they're not major. I'm looking at my studio setup and thinking eventually I'm going to get the lighting right, but apparently tonight's not the night. So forgive me if I look a little gray. Part of it is the gray walls. Part of it is sort of equalizing some of the rest of the light sources in the room. And, usually by 6 o'clock in the evening, I'm not paying attention and coming up here to tweak my lighting. So I need to come up one evening and work on how to get the lights set up for when it's 6 o'clock at night, because that's different than what it is at noon. So, first thing I want to talk about is Corey Richins. She had a motion hearing yesterday, and primarily what she was asking for was bond. And it was a fairly lengthy hearing. Her current attorneys, who replaced Sky Lazaro and her team, her current attorneys made cogent, reasonable arguments for why she should be released. One of the probably the biggest changes is they're not seeking the death penalty, and so that makes her eligible for bond, where she would not have been eligible for bond in the death penalty case. So they made some, I thought, not unreasonable arguments. They weren't just making arguments to say they did. And we'll talk about some other cases where I think that's more the case. But in the Corey Richins case, I didn't feel that they were really asking for things or making unreasonable arguments. Despite that, the judge found that he wasn't persuaded by their arguments and denied her request for bond. So her trial is now scheduled. Oh, wait, I have it in my notes here. I want to say March, but I could be wrong. So, her trial, see, I have a page for every month. So it is April 28th is when her trial is scheduled. So, I'm sure that we will see a few more preliminary motions. We'll see motions in limine. We'll see some evidentiary motions. All of that, those things, probably coming up sometime after the first of the year. Sarah Boone has asked for a new trial, and she's basing it on bad rulings from the court and prosecutorial misconduct in how they handled discovery primarily. I don't know that either one of those fly. I don't think that the judge made any particularly bad rulings or egregious rulings. And I think that he was very cautious, like extraordinarily cautious, going way overboard to, at every turn, ask her whether she had had time to consult with her lawyers and whether she was satisfied with their advice. So I don't think that she's going to be able to claim any kind of ineffective assistance of counsel or any other lawyer-related complaints. So I think she's sort of stuck with complaining that the judge's rulings were unfair or incorrect, and complaining about the prosecution and potential misconduct surrounding discovery. I don't think either one of those go anywhere. I don't think she's going to get a new trial. And then I think she'll move on to filing direct appeals. So, Long Island serial killer Rex Heuermann. It's interesting. The defense says they may file a motion for a change of venue. They're in the process of doing research associated with that. Although, as he said, the lawyer said, we're not sure where an alternative would be, except maybe on Mars, to outrun the pretrial the pretrial publicity. They also have filed a challenge to, or are going to file a challenge to DNA, to the DNA processing. And specifically, and I'll tell you, if you want a deep dive into DNA and the way it works in criminal trials, in our show notes is a Lawyer Lee episode where she interviewed a woman whose name now escapes me, who explained how genetic genealogy works and explained how DNA works. And specifically, this SNP, or as they call it, SNP um, DNA analysis. And that is what they intend to challenge. Um, it was interesting because earlier today I was watching a now I cannot remember which trial it was. It was a hearing on an upcoming trial. And if I find it in my notes, I will let you know. But I thought what was really interesting was they had a lawyer who was extremely well versed in the technical aspects of DNA analysis. Oh, no, this was phone extraction analysis. And what they were, what the attorney was doing was really digging deep into how the investigator understood the extraction software and how it had changed and how, and you know, there's a difference between someone who understands the reason why the extraction software works and somebody who just knows enough to plug the phone in and do the extraction. And it was very clear that the attorney that was questioning them, it was a pretrial hearing, knew exactly what to ask to point out that this particular expert was really an expert on how to get the information out of the phone and not really an expert on the software and how the software for the extraction plays into what gets extracted. And that was really interesting. So I think that as time goes on, we're going to see more of these very technical challenges to scientific evidence. And those are that is usually done in what's called a Daubert hearing. Daubert is a U.S. Supreme Court case that set the framework for how to decide whether a technology is actually scientifically reliable or not. And I think we're going to see a lot more of those. We're certainly seeing challenges to a lot of the technology that came up in Delphi, and we're going to talk a little bit more about that as we go forward. The next case I want to talk about is Shanna Gardner. Those of you who might not be familiar with the case, the victim in the case is Jared Brightigan. He was a Microsoft executive. Shanna Gardner is the daughter of the family that they were involved with scrapbooking and rubber stamps. I think the company is called Stampin' Up. And they, as a result, got very wealthy. So she's from this very wealthy family. And Jared Brightigan was a Microsoft executive. They were divorced, and she and her second husband enlisted the assistance of a third party to kill Jared Brightigan. This is the case where he was driving home after dropping their mutual children off, he and Shanna Gardner's mutual children off. He had one of his children with his second wife in the car with him. Someone put a tire in the road, and when he stopped and actually was, I think, trying to get out to move the tire, a guy stepped out and shot him. Shanna Gardner was arrested. She was arrested in the state of Washington and extradited. She and her current husband are both in custody and awaiting trial. And she recently And recently, when they released a probable cause affidavit, there was information redacted that indicated there could be as many as 2 other people involved, in addition to Shanna Gardner, her second husband, and the third party guy that they enlisted. So we'll wait to hear how that case unfolds. I have lots of notes about Karen Reed I'm going to get back to. Several people asked me about the Larry Millette case. It was scheduled to go to trial in July, but the court recently, it was set to go in September. And the court recently vacated the September trial because of claims that Larry Millette's retained lawyer never saw him, didn't provide him with his discovery, and that his parents gave this attorney access to his financial accounts. And they now claim that she defrauded him of $250,000. He recently was in court requesting that he be permitted to have contact with his children. The judge has denied that, ordered a no contact, but his new attorneys, his current attorneys who replaced the one that apparently defrauded him, appear to be facilitating some sort of contact. Now, what they're accused of doing is playing for him a video his children made for him with an Easter greeting. Now, I think there's a good argument that that's not really contact. I mean, the children are not having contact with him. They're not having contact with his lawyer. They actually had a video that they showed their client, but that doesn't. I kind of agree that doesn't amount to contact. So he is now set for trial in July of 2025, July 7th, and so we will keep up on that one as it comes around. Brian Kohberger from University of Idaho murders was in court again with his attorney Ann Taylor. And they were there arguing motions having to do with the death penalty. So, as I've explained before, anytime a lawyer has a death penalty case, they're going to file challenges to the death penalty, whether it's that the death penalty is unconstitutional, whether it's that the death penalty as it's written in their state it amounts to cruel and inhuman treatment, a number of those sorts of motions. As I've said before, one of the reasons is that law gets changed in increments, sometimes in tiny little incremental decisions from courts. And so all criminal attorneys are always looking to extend the law in their particular area or with a particular issue. And that is certainly true with death penalty lawyers, because death penalty lawyers are always attempting to expand the legal definitions of things, expand the challenges to things. And so what happens is it's very common for these motions to be filed. I think what's a little bit unusual about these motions is they are specific to the state of Idaho, and the fact that the state of Idaho, as it currently stands, does not have an effective way of carrying out the death penalty. we've talked about this before, but many, um, in fact, I would say most of the companies that manufacture the drugs, or as they like to call it, chemicals, that are that are used in a lethal injection execution. Many, if not all, of those companies refuse to sell to states who intend to use their drugs for the purpose of carrying out an execution. Many of them would say that that violates a Hippocratic oath, and it violates their ethical stand on using these drugs to help patients and to heal patients, not to end their lives. That being the case, states have had to resort to finding these chemicals in other places. In some instances, they find them in overseas markets. They're also able to find them in what are called compounding pharmacies. That is a pharmacy that creates the drug from its formula from scratch. In some cases, for example, um, in uh, in the case of some of the antiviral drugs for COVID and some of the other COVID related drugs, the FDA uh, gave approval to compounding pharmacists to compound certain pharmaceuticals because they were in short supply. So some states, including Idaho, have found compounding pharmacies that will create the drugs that they need in order to carry out an execution. So recently, there were two men who were on death row. One of them's last name is Creech. He received his death warrant. The death warrant was signed, and his execution was scheduled. He was taken to the execution chamber, and when they attempted to start an IV so that they could administer the drugs, they could not get an IV started. Now, one of the problems is also the difficulty that doctors and nurses believe that participating in executions is not an it is untenable ethically for them as well, because it violates their ethics and their beliefs, their Hippocratic oath. So oftentimes, people who are not well trained are the people who are starting these IVs. And so after trying at 8 different points in his body, they determined that they were going to be unable to carry out the execution, and the execution was canceled. So that has got to be absolutely nerve-wracking and distressing beyond belief for a person. And in fact, Mr. Creech has brought suit against the state for cruel and unusual punishment, or cruel and unusual treatment. And so what Ann Taylor was doing in the Kohberger case was saying, look, Judge, we do not have a reliable method of carrying out an execution. And the only other alternative is that Idaho last year resurrected the firing squad. So the state of Idaho, as we speak, is building a firing squad chamber where firing squad executions could be carried out. So Ann Taylor's argument was, we do not have a reliable method of carrying out an execution. And that means that Mr. Kohberger is going to be subjected to that same cruel and unusual punishment of not knowing whether or when the state would be able to actually carry out the sentence. I don't think it's a super strong argument, but knowing attorneys as I do and understanding that you make every possible argument because you set them up for appeal, it was incumbent upon her and probably would have been malpractice had she not filed those motions on that basis. So the judge had some very good questions, and I think that ultimately that is not going to be it. Certainly, and Taylor's um, uh, contentions are not going to carry the day. So um, there are still many, many things to talk about in the Kohberger case. It's currently set for August, I believe, of next year. And I think we're going to see hours and hours of pretrial motions and motions in limine and evidentiary rulings. So I think that's just sort of the first volley of those. So I want to move on to James Craig. Several people asked me about this case. He is a Colorado dentist accused of poisoning his wife with eye drops and cyanide. Interestingly enough, that trial is set for the 2nd of December, so it's coming up. And interestingly enough, he recently attempted to frame essentially to frame his wife for framing him. It's kind of hard to understand, but he had a jail pod mate of his. He wrote to him and said, I want you to find 2 women, strangers, and I want them to contact the police and tell them that his wife, the victim, had told them that she was going to frame him for her murder. It's crazy and convoluted. But this is the schemes that come from somebody who has too much time in jail on their hands. So his attempt was to have these strangers say that they had known his wife and that she had confided in them that she was going to set him up for murder. It's crazy, but he got caught when the letter he sent to his pod maid came back as undeliverable to the jail. So, Chad Daybell is still on death row in Idaho. The appeal has been waiting because they've been waiting for this lengthy transcript. The transcript was finally filed on the 17th of July, but we're still waiting for the initial briefs. The defense has filed for and been granted additional time to file their opening brief. Now, in appeals, what happens is you file your notice of appeal. And once the appellate court receives the transcript and they say, okay, the transcript is now complete, then they give you, it's usually 30 to 45 days to file your opening brief. The moving party, the appellant, files their opening brief, the other side answers, and then there can be sort of like surrebuttal. Rebuttal and surrebuttal. It depends on the court and how much they will allow and what they want. But then at that point, they schedule oral arguments. If they're going to hear oral arguments, sometimes they don't. Sometimes they affirm without hearing oral arguments or writing an opinion. They do that based on the briefs. And oftentimes it is because they believe that there isn't really a colorable, appealable issue. There isn't a colorable um, issue at hand, and so if they don't, the court doesn't believe that there is a um, that there is a reasonable grounds for appeal, then they can just say we've reviewed the briefs and we're going to let the lower court's ruling stand, and we're just affirming it without writing an opinion. So that happens. And that may happen in Daybell, although usually in death penalty cases, everyone errs on the side of caution, and generally they set oral arguments, and generally they do write an opinion, even if it's quite brief. Lori Vallow. She is still in Arizona, being held at the Maricopa County Jail, and still waiting for a mental health evaluation, as far as we know. The judge, at the time that her attorneys withdrew, prior to that, they filed a motion asking the court to have Lori evaluated, to have her mental health and her competency evaluated. Now, remember, we're talking about current competency, not her state of mind at the time of the crime. So we're not talking about an insanity defense. We're talking about whether or not at this point she is able to aid and assist with her lawyers. So that the judge did order that she be evaluated once again for her competency, and we're waiting to hear those results. In the meantime, her lawyers, then after that, her lawyers asked to withdraw, and Lori asked that there be no new lawyers appointed for her, that she wants to represent herself. I don't think there's any greater indication that he who represents himself has a fool for a client than in this case. However, she does have the right to do that if she's competent. So the judge has said he is not going to make a decision about whether or not to allow her to represent herself until he receives the reports on the competency evaluation. So there we are. There's kind of an interesting case that happened in Idaho about the time the Daybell trial was going on. And it involves Ann Taylor, who is Brian Kohberger's current lawyer. And the case is Skyler Mead. So Skyler Mead was being held in custody on a 20-year sentence for shooting a police officer. And he either feigned or was ill enough that they took him to the local hospital. And at the hospital, he and a friend created a diversion and committed a violent escape that included injuring several people in the process of his escape. So they were recaptured, and he's already pled guilty to the escape charges. Of course, it was all on video in the hospital because everything's on video. And so he pled guilty to the escape charges. Because he is a violent offender and a repeat offender over and over, he's a repeat violent offender. They sentenced him to life in prison with parole after 30 years. But he has also been indicted for murder in northern Idaho while he was out on escape. So after he escaped from the hospital, before he was recaptured, he and this friend that he escaped with um, are believed to have committed two murders in northern Idaho, and they've both been indicted on one of them. So, and Ann Taylor represents him. Now, there's some interesting developments in the public defense system in Idaho. And this is happening in quite a few places. It's happening in my home state of Oregon. I know it has happened in Washington as well. So what's happening is that there has been a nationwide, and we've talked about this before, a nationwide shortage of public defenders. There are some really clear and obvious reasons for that. Public defenders are expected to carry crippling caseloads. They're not paid enough. It's just not an attractive enough job. And so young people coming out of law school are just not being attracted to public defense. What it means is that the brightest and the best are going into private practices and into civil law and into state attorneys general and prosecutors' offices. And so we're not able to attract public defenders. And the folks my age are retiring. And it's just created a crisis in public defense. So, in order to answer that, states have been changing the models for how they contract with, pay public defenders. For example, in Oregon and to some extent in Idaho as well, public defenders are paid. They are private contractors who contract with the state. The group that I worked for, we were a consortium of public defenders, and we had all gotten of sole practitioners, and we had all gotten together to be a contracting unit, a consortium to contract with the state of Oregon. There are some things that are problematic about those models, and a lot of states are moving to a state agency that then has public defenders. By doing that, they're able to give them salary parity with prosecutors and attorneys general, and they get state pension participation and healthcare and vacations and a lot of stuff that as a private contractor you didn't get. So a lot of states are making that transition. And one of the states that's making that transition is the state of Idaho. And Ann Taylor has been hired or tapped to be part of the administration of a statewide public defender. And so she has continued to say that she wanted to stay on as Brian Kohberger's lawyer. I suspect that the Skyler Mead case is going to wrap up. He's already pled guilty to the escape, and I suspect that there will probably be a guilty plea to avoid the death penalty when it comes to the other murders he's been accused of, because he's already been sentenced to life with parole eligibility in 30 years. So with that already under his belt, it would seem silly to me not to take a similar life plea and get out of the death penalty. But Ann Taylor will be, and this is both good and unfortunate at the same time. Ann Taylor is an incredibly smart, very experienced public defender, and I think she's going to be a huge benefit for the state of Idaho, in that she's going to be part of the administration of public defense. She's going to be in there helping set up training programs for new lawyers coming in, those sorts of things that are difficult, if not impossible, to do if you are a private contractor. If you are a government agency, then it's much easier to set up training programs, to to work with new people coming in and begin to cultivate some experienced, smart public defenders, and not to really feel like the only people who are going into public defense are the people who can't make it anywhere else. So it's good for the state of Idaho, but it's going to be bad for Ann Taylor's individual clients. It does appear that she is trying to finish out cases that she has open, and as far as I know, has said that she is committed to seeing Brian Kohberger's case through. Dale Warner is set for trial in November of, oh, I'm sorry, September of next year. His charge is for his wife Dee, who for several years was missing. Her family filed and asked the court to find that she was deceased, so that they could bring a wrongful death suit against Dale Warner. And then the state began looking into it, arrested Dale Warner, and but at that point, Dee's body had not been found. Since then, Dee's body was recovered out of a big chemical tank on the property that they owned. Was used for some sort of farm chemicals, fertilizer or something. And one of the things I thought interesting about the Warner case, it's in Michigan, and there they file an open murder indictment, and that allows the jury to decide what degree of murder applies in the case, which I found really interesting because in most states, it's the state statute that decides what degree a murder is. And states vary from state to state. In some states, the only first degree murder is if you kill a cop. Other states, first degree murder if you do it while you're in the commission of a felony. And other states, it goes back to sort of the common law of did you knowingly and with malice aforethought end a human life. So every state defines murder slightly different, but it's interesting to me that in Michigan, it's the jury who decides what degree that charge is going to come back at, not the prosecutor. Crystal Rogers. Crystal Rogers, her body has never been found. She had a fairly wealthy boyfriend. It's an odd case because her father was out searching for her remains a year or so after her death and was shot and killed in the forest. And his murderer has never been found either. But Brooks Houck, who was her former boyfriend, and Joseph Lawson are scheduled to go to trial in June of next year. But interestingly, Joseph Lawson, who was a friend or acquaintance or worked for Brooks Houck on his property, I believe. His father was also involved, they believe, in the moving of Crystal's body. He is scheduled to go to trial in February. So he's going to be tried in February, and then Brooks Houck and Joseph Lawson will be tried jointly in June. I think that's going to be interesting to watch because if evidence comes out during Steve Lawson's trial in February, it may force a plea before the second trial. So if the first trial goes uh, well for the state, it may signal that they want to, it may signal them that they probably need to enter a plea. And then lastly, before we dig into Delphi and Reed, I want to talk about Falls City, Washington. Um, these young people have not been named, so the case doesn't really have a name. It was a family massacre. Um, so what the prosecution says, and this was a question from Carrie. So Carrie, if you're listening, and we are going to talk about what are called Kent criteria for um, for prosecuting juveniles as adults. The reason I wasn't familiar with Kent criteria is because the state of Oregon has its own statute about when you can try a youth as an adult. So my home state didn't use the Kent criteria because we had local statutory criteria that applied. It's similar to the Kent criteria, but so the facts of the case are that there was a 15-year-old brother who is being accused of having murdered his entire family. One sibling, one 11-year-old girl, survived. The rest of the family were murdered. The 15-year-old defendant claims that it was not him, that it was his 13-year-old brother who committed the murders and then committed suicide. However, the 11-year-old girl who was injured says she saw the 15-year-old boy shoot the family and that he staged it to look like the younger brother had done it. So that one's going to be a little bit interesting. The defense has asked for access to the property so that they can do their own investigation of the scene. Now, the prosecution, of course, has taken, lots of pictures and measurements and all of those things. But the defense is saying that's not sufficient. We want our own investigators to go into the home. But the grandmother, who is currently the guardian of the one surviving child, is arguing that the court should deny the request of the defense. So the judge is going to have to decide whether to let the defense in. My suspicion is that the judge will allow that. We saw that happen in Kohberger case, and Taylor and her team, within a day or two of Brian Kohberger being arrested, she had a team in the house, and she had her own investigative team looking at the crime scene. The prosecution is arguing that the court should deny juvenile jurisdiction because of the Kent factors. So I want to take a look at the Kent factors because Carrie asked us. So it's a little hard for me to read from this distance, so I'm going to look over here at my auxiliary screen and read it from here. The first criteria is the seriousness of the alleged offense to the community and whether the protection of the community requires them to decline. There in Washington, and this was a U.S. Supreme Court case, the mechanism is that the juvenile court declines jurisdiction. That means he's automatically to be treated as an adult. So the seriousness of the alleged offense to the community and whether the protection of the community requires that he be tried as an adult. Second, the manner that the offense was committed, whether the alleged offense was committed in an aggressive, violent, premeditated, or willful manner. Third, persons or property, whether the alleged offense was against people or property, greater weight being given to the offenses against people, especially if personal injury resulted. Merits, the merit of the complaint, the merits of the probable cause. Okay, meaning that there is probable cause to believe that this particular individual committed this specific crime. Adult co-suspects, the desirability of trial and disposition of the entire offense in one court when the juveniles association in the alleged offenses are adults. That is not applicable here. There are no adult co-defendants. Sophistication and maturity. The sophistication and maturity of the juvenile as determined by consideration of his home, environmental situation, emotional attitude, and pattern of living. So we clearly have the most serious possible crime. I'll get back to the last one here in a minute. We clearly have the most serious possible crime, murder, committed in an aggressive, violent, and apparently premeditated way if we believe that he staged the scene to make it look like his 13-year-old brother committed the crime and then committed suicide. It was to persons, not to property. The merit of the complaint is something that the judge would have to weigh, but remember, the issue is only whether or not there's probable cause. That's a more likely than not standard, not a beyond reasonable doubt standard. No adult co-suspects. His sophistication and maturity, they would consider his home life, environmental situation, emotional attitude, pattern of living. What also comes into play there is whether or not there are any intellectual disabilities or any processing disabilities. So the first ones have to do with the crime. You can see the second ones have to do with the kid. So the record and previous history of the juvenile, as far as we know, this kid does not have a prior history. That is not particularly persuasive in a murder case. It is in cases other than murder, violent kinds of crimes where, but in a murder case, it's not particularly persuasive that he was a minor or that he has a criminal history. The younger the minor is, the more these last considerations tip in their favor. So the younger the offender is, then the less likely it is that that child can be held accountable. Now, there are other US Supreme Court cases which talk about the fact that juveniles are not small adults and that we have to consider their developmental stage as we determine whether or not they should be tried as adults. And then the last is the prospect for rehabilitation versus protection. The prospects for adequate protection of the public and the likelihood of reasonable rehabilitation of the juvenile by the use of procedures, services, and facilities currently available to the juvenile court, assuming he is found to have committed the alleged offense. So the reason why it says available to the juvenile court is even though this person is tried as an adult and could be adjudicated as an adult, the person, this offender, would not serve their sentence in adult jail unless and until they were an adult. typically what happens is it depends upon the facility, and it also depends upon the behavior of the defendant. So normally what would happen is, say you have a young person who is convicted at age 15 or 16 of murder. They would remain in juvenile um, detention. Remain remanded to the juvenile authority and not to Department of Corrections until they reach 18. In some jurisdictions, a lot, in fact, that offender can remain in juvenile authority until they are 21, as long as they are behaving themselves and not creating security risks or not causing problems within the juvenile system. Once they turn 18, if they are problematic, they will be transferred to Department of Corrections. So the issue of rehabilitation, there is no question that statistically, children are more likely to be rehabilitated and are less likely to reoffend than adults. They are more, just as their brains aren't entirely finished and their frontal lobe and their judgment is not entirely developed, they're also at a place where their personalities and their brain development and their frontal lobe are still in a plastic state, as is what the experts call it, and is able to be revised or re they're able to change, and they're able to learn new behaviors. And once a person gets into adulthood, those personality traits become much more ingrained and much less likely to be changed with any kind of treatment. So it's likely in this case that the juvenile court will find the court will find that it is appropriate for the juvenile court to decline jurisdiction and for this young man to be tried as an adult. That doesn't mean that he and this was true of um, the school shooters, a lot of the trials that we've seen. One of the reasons why his trial was that's the Crumbleys, Ethan Crumbly and his parents. One of the reasons his trial was not live streamed, but their trials were, is because he was a minor, and it is not permissible in most jurisdictions to live stream a minor's proceedings. Generally, juvenile proceedings are sealed and they are not open to the public, but so it is not appropriate for them to be live streamed. So now I want to talk a little bit, before we end with Delphi, I want to talk about Karen Reed, because she just had some a fairly lengthy motion hearing. A couple of developments in the case. They asked for Judge Canoni to be recused. That was declined, so she is still on the case. I'm sure that didn't endear her to the defense in any way, but I'm not sure she was particularly endeared to them to begin with. Let me just pull this down now that we're done with it. So there were several motions that had to be heard. The prosecution had filed, before we get to the motions, the prosecution has brought on a new prosecutor, someone who is a very experienced prosecutor and who has taken charge of the case from DA Lawley. That's not a bad thing. For those of you that believe that Karen Read is guilty, that is not a bad thing. To bring on somebody who clearly has a good grasp of the criminal trial and criminal procedures. So the first thing the prosecutor did was file several Rule 17 motions. Again, states vary on how this process works, but under the Massachusetts rules of criminal procedure, if you are going to subpoena information from a third party, such as phone records from Verizon, the opposing party has to be served and has to have an opportunity to object. In this case, one of the things they're attempting to get is Karen Read's father's phone records. So there was a little bit of confusion about where it stood, whether it had been served, and so the judge put off a decision on that. Although she's going to have that hearing fairly quickly because they need to move the case along. So the next thing was the defense filed a motion for relief from the impound of the recorded sidebars. Now, this makes sense when you actually hear the discussion in court. The defense is not asking that those private evidentiary sidebars be released to the public. They're asking that the impound be lifted as to the attorneys on both sides, because the prosecution now has this new lawyer who's come in, wasn't present during the last trial, didn't hear those evidentiary sidebars and the rulings. And so is that something of a disadvantage? So they're asking that the recordings of those sidebars be transcribed and released to both sides. And that makes perfect sense. They did clarify that they are not seeking transcripts of any of the juror conferences that the judge had with the jurors, including any questions that they had of jurors after the trial was declared to be a hung jury. There was a sort of general motion for the defense had filed for discovery of communications in possession of the Commonwealth. They weren't specific, although there may have been a specific list attached to their motion as an appendix, but it wasn't, the specifics weren't addressed in court. The new prosecution attorney said that he wanted to be able to respond in writing. And that makes sense. Anytime there's discovery where you're talking about what you're releasing or what you're sending, it's good to put that all in writing so you have a record of what you sent. And so they're working on it and going to put it all together and document what's provided. The judge set a deadline of November 27th. She also set a deadline of November 22nd. Oh no, I take that back. They set a hearing for November 26th on the issue of the Rule 17 motions for phone records. So probably the two most significant motions were and this one wasn't even really a motion. The Commonwealth noticed the scheduling of the reassembly and analysis of the Lexis telematics system. If you'll recall, the navigation entertainment system that was in Karen Reed's Lexus was downloaded and analyzed. So the way it was explained is they got into this discussion, and the defense had objected to them doing that. So here's the way it was explained. Um, the prosecution's new expert found that there was unreadable data, and it was unrecovered because it was read with the wrong reader, both hardware and software. So what they discovered was that there were 4 modules, chips in this system. Some of it has to do with navigation, some with key on, key off, those sorts of things. Some had to do with the entertainment system. So what they realized was that what has to be done is those circuit boards, those little chips in the motherboard, have to be physically removed from the motherboard and then connected to a piece of hardware that will then download any usable data. Of course, the defense is concerned that if that's not done correctly, that they could be damaged beyond being reread. So they wanted their own expert. It's almost a consumptive testing argument because they want their own expert to be present to make sure that when those modules are disconnected from the motherboard, it's done properly so that they're usable. So the defense, the prosecution said it could be essentially destructive testimony, but the defense knew that the first time they did these extractions. And actually, the prosecution said they deferred to the defense to do the original extraction and that the defense expert didn't do it right. And this information is needed to support the accident reconstructionists' findings, and the accident reconstructionists can't move forward with their analysis until they get this data. So what the defense said was, at the time that the original extraction was done, the Commonwealth didn't have an expert who knew how to do this extraction or had the ability. So the defense experts did it. Since then, new software has been developed that allows for a better outcome for the extraction. So they're not objecting to the new extraction being done, but they want to have their expert there to be able to watch, and if something looks like it's not right, be able to say, wait, stop, until we let the court know what's going on and get a ruling from the court. The Commonwealth didn't want them to have veto power over the process. So Judge Canoni took all of these under advisement. She did not make any rulings from the bench this time. The last motion was a joint motion to continue the trial until April 1st. Now, the prosecution made the argument that this new prosecutor has come on board and that they have hired a whole slew of new experts, and all of these new experts need time to do their analysis. some of the experts need the information that they're seeking in the Rule 17 motions and to subpoena records from third parties. And so they feel like they need extra time. Also, part of the problem is they have new experts. These new experts are doing their analysis. Then they have to turn those reports over to the defense because the defense hasn't seen any of the new experts' analysis. And they have to have time to have the new experts work checked with their experts and be able to give feedback and file any objections that they may need to do in response. Some of that may result in Daubert hearings. Daubert is the US Supreme Court case. It's what we call cases that challenge the scientific basis for or the reliability of scientific evidence. So the Commonwealth has already said that they intend to ask for a Daubert hearing on the woman who came and gave testimony about the dog bite. And they also may be asking for Daubert hearings on some of the extractions and the technology that's happening on that auto extraction and accident reconstructionist. So they made a very good case for the reason that they need to move the trial from January to April. I think the judge is going to allow that, but I thought she was going to allow a continuance last time and she didn't. So I don't know. The Commonwealth said that if she denied the motion, they would do their best to be ready in January to go forward, but that they're that they definitely would prefer and feel that it would be a more streamlined trial and there would be much more ability for them to better organize their case and their experts if they had some extra time. So Judge Canoni took those all under advisement. The next hearing is the 26th on the Rule 17 motions. So it's possible she could make some rulings at that time. But she just seems anxious to get things moving ahead of the trial date. Lastly, we need to talk about Delphi. So you all know that I think that Delphi had a myriad of problems. Despite that, a jury found Richard Allen guilty on all counts. There were 4 counts. One is a felony murder count, which just means the murder was committed in the furtherance or in the process of a different felony. In this case, kidnap, and then the straight murder. It's not unusual for prosecutions to charge someone under different theories and for juries to bring back guilty verdicts on more than one version of the legal theories. So there were 2 different legal theories for each victim. What happens is those under the US Supreme Court, those convictions merge for sentencing. So even though he is found guilty on 2 counts for each girl, he'll only be sentenced to 1 sentence on each girl. So they've asked for a pre-sentencing evaluation, and I believe his sentencing is set for December 21st. If you listened to any of the three lawyers who were present during the trial, Andrea Burkhart, lawyer Lee, Bob Mata, Bob and Allie from Defense Diaries. You certainly could understand their belief, having sat through the trial, that the Commonwealth, that I'm sorry, the state had not met their burden of proof and had not proven beyond a reasonable doubt. Despite that, the jury, after 2.5 or 3 days of deliberation, came back with a guilty verdict. I think that this entire case is incredibly problematic. I am certain that, in fact, his attorneys have already said that they intend to appeal, and I'm certain that appeals are going to be flying fast and furious. They're also, of course, going to file a motion for a new trial that is going to go nowhere with Judge Gull, and it will get elevated to the Supreme Court. I understand that there are people who believe that Richard Allen is guilty, and I cannot say I believe Richard Allen is innocent. I believe that the state did not prove that Richard Allen is guilty beyond a reasonable doubt. Further, I believe that the investigation was so poorly done and so rife with confirmation bias, where the police were looking to confirm their suspicions, that I'm not sure we will ever know who actually murdered Abby and Libby. And it is very unfortunate for both sides, because justice means justice for both the victim and the defendant. In most cases, it means a defendant being held responsible for their actions, and for the court, for either the defendant to accept responsibility and enter a plea, or for the state to prove beyond a reasonable doubt that that person is guilty. I don't see how you get to him being guilty from a single bullet that, while it could not be excluded as having run through his gun, it also could not be excluded as having run through a couple of other guns, including the guy who drove the notorious white van. So I think the case is very problematic. I understand that there are people out there who say, even if he was psychotic and had made some of his confessions while he was in the grip of psychosis, he later made other confessions after his mental health professionals said he was no longer suffering from psychosis. I think that there are some real questions about the quality of the mental health evaluations and treatment that were done at the prison. And I think that it is impossible. Their own witnesses, their own mental health witnesses said people can shift in and out of, lapse in and out of psychosis. So, and it is possible for someone to sound relatively lucid and still be psychotic. They don't have to be unintelligible and be talking about things that are unrelated and be catatonic, as some people describe much of what Richard Allen said early while he was decompensated. But people can be in psychosis because they are not in touch with reality, and they firmly believe something that is not real. So I think that it is very, very unfortunate that the jury wasn't able to parse that out. I think it's unfortunate that Richard Allen's lawyers were thwarted at every turn as they tried to put on a defense case. Not only that, but Judge Gull made some pretty ridiculous and outrageous evidentiary rulings during the trial. Very uneven, allowing the prosecution to do things and then not allowing the defense to do exactly the same thing. I mean, it was pretty blatant and egregious in her rulings. So I'm not shocked, although I think I was surprised that the jury found Richard Allen guilty, and disappointed. And I think that it raises some real questions between Delphi and Reed and Sandra Birchmore and a few other cases where law enforcement is so absolutely convinced that they have the right person that they don't investigate other options, that they don't investigate other alternative theories, and in some cases actively cover up alternative theories, because there is a lot of police investigation problems in Delphi. For example, there were 10 witnesses whose recorded interviews were lost, and the law enforcement never even made a list of who those people were. They just said, "Oh, well, we lost a bunch of interviews, and no harm, no foul." And it's very clear that there was harm and that there was foul, and that there possibly was illegal activity going on the part of law enforcement. And I think it's what I always say, and I have repeatedly said on Twitter recently, is that if we don't protect the due process rights of everyone, then they're not available for anyone. If we don't protect Richard Allen's due process rights, and we don't require the police to act ethically and act properly, in his case, whether he's guilty or not, we don't protect those rights when we as citizens need them. We don't protect the innocent if we don't protect the guilty. And so it's frustrating that so many people, including Delphi law enforcement, were willing to say, he's guilty, so we don't really, well, we know he's guilty. We don't really need to put the shoe leather in and the effort in to make sure that the case passes muster and that he can be convicted and his due process rights can still be protected. That is the hallmark of a good prosecution, is when the prosecution and law enforcement have done a thorough investigation and believe that their case supports a conviction of that individual. And then when the defense goes to court, their job is to assure that his due process rights are protected and all of his rights are observed. In this case, that didn't happen. His due process rights were trampled every which way from Sunday. And we can never know for sure whether Richard Allen is guilty of killing Abby and Libby because of that, because the law enforcement took shortcuts, undermined evidence, undermined the investigation to the point where we will never know. And remember, this investigation happened years ago. These witnesses gave their statements years ago. Memories fade, recollections get dim. What we know about memory is that every time you remember something, you're actually rewriting it to your brain storage. You're not just accessing it like an old video and watching it. You're pulling it up, remembering it, and rewriting it. And errors occur when you rewrite stuff in memory. And those things happen. And so it is possible for people's memories to fade, for them not to remember things that they did a long time ago, and for them to remember it differently than they did a long time ago. And the longer it takes, the more difficult it is for witnesses to clearly remember. That's why interviewing witnesses and memorializing those interviews at the close to the time of the crime is so incredibly important. And that's what did not happen for Richard Allen. A lot of those interviews were lost. People were re-interviewed after Richard Allen was identified as a suspect, and and that colored because they had publicly announced that Richard Allen was a suspect and had released his pictures and released the bridge guy video. All of those witnesses were now giving their statements in light of knowing that information. So there were a lot of shortcuts. There was a lot of confirmation bias, and there was a lot of very sloppy police work. All of that has resulted in Richard Allen being found guilty of a crime that I think it's possible he didn't commit. Do I know that for sure? No, I don't. Nobody does except Richard Allen. But the evidence that was presented at trial leads me to wonder. It leads me to believe that there is reasonable doubt and to wonder whether there could be some other explanation for the crime. And if that's the case, then if it is possible that Richard Allen didn't commit this crime, he should have been found not guilty. And the Indiana jury instruction says that outright. So, and it's hard for me to believe that in 2.5 days, there wasn't some reasonable doubt in the jury's deliberations. Nonetheless, he was convicted. So it's certainly a case I'm going to continue to follow. It's a case that I'm really interested in. There may even be a book in it for me. So that's where I'm coming from on it, because I think it is possible that there was a terrible miscarriage of justice. It's also possible there wasn't. But again, if it's possible that there was a miscarriage of justice, I think that it's incumbent on all of us to investigate that and to give Richard Allen the presumption of innocence, which I don't think he got during his trial. So with that, I'm almost running out of voice. However, it's time to take some questions. So I've seen in the chat that Jen has been starring some questions. While she sorts questions and gets the first one up, I want to remind everyone, please like and subscribe. We're kind of noticing subscribers dwindling. Maybe it's because the Vallow Daybell case is resolved and people are sort of getting ready to move to the holidays, and there's a lot going on in other people's lives. So if you have not subscribed, please consider doing so. Hit that notification bell so you get notified when we go live. That is typically every Wednesday at 6 Pacific. However, we have been known to do surprise lives if there is important if there are important developments in the cases that we follow. So, also want to remind everybody my email address for those who may have questions and maybe aren't comfortable doing it publicly. My email address is in the comments. I also do look at all of the comments and questions that are in the comment in the chat as well as in YouTube comments. So please feel free to use both of those. The holidays are coming up, and so we will be missing a couple of lives around Thanksgiving and Christmas, but up until then, we'll be seeing you weekly. And I finally, last week, got my quilting space, my sewing space set up, and we are still accepting quilt blocks for a quilt for Larry and Kay Woodcock, who are J.J. Vallow's grandparents. They are look like an origami crane. They're foundation pieced, and they finish at 6 inches. And the pattern is the link to the pattern in my Google Drive is in our notes as well. So we are going to have a couple of other things coming up. We may do a couple of other little projects and things to get people interested. And we've done a quilt along before. We might do another one of those. So I hope that you will subscribe and you'll follow along with us. I do also post in our show notes when I mention another creator or another somebody else's work that I found interesting, videos, those sorts of things. They're in our show notes as well. So there's a link to Andrea Burkhart's YouTube channel, a link to Lawyer Lee's episode on DNA, and I always encourage you to follow them as well. So we're ready for questions. Hi, Jane Blackbird. Are the charges against Karen Reed the same as the first trial? Yes, they are. The Commonwealth was very clear that they were going to bring identical charges to the last case. The defense filed appeals saying that they believed that the jury had reached a verdict on 2 of the 3 charges, and so double jeopardy attached, and she should not be retried on those motions. That is another reason I think that the Reed trial is going to get set out, because I think they would like to have the appeals court make a ruling on that before they proceed to trial. The defense would like that. I don't know whether it will happen or not. Judge Canoni certainly wants to push things forward, and so it may be that that she says, no, you're not going to get a continuance, we're going to go forward, and then that will end up that trial will end up being appealed on the basis of the fact that there was a pending appeal that hadn't been decided, and it will all stack up. So please stay tuned. For Feline Mom, a $20 super sticker. Thank you so much. Thank you very much. I appreciate that. We don't really, we appreciate them when we get them, but we don't really ask for super stickers. So we appreciate them when you share with us. Your generosity is always appreciated. But we're not operating this YouTube channel as a commercial enterprise. I have thoroughly enjoyed connecting with you all, with this true crime community. And I say we have the best community going. Our chats are always stimulating, but also really uh, uh, polite and respectful, and I appreciate that more than you know. So so thanks for the super sticker, but you don't feel like you have to make donations in order to participate in our community. Um, so but for feline mom, that was very sweet of you. My cats aren't here today. They aren't true crime catting today. Last time I had one hanging out on the cat tree and enjoying himself and making himself known. So eat the food, Tina. I'm with you, Tina. Is Lori Vallow being evaluated to determine if she's competent to stand trial or if she's capable of defending herself? Well, I think her attorneys originally asked for her to be evaluated to determine if she's competent to stand trial. But I think the judge feels like if she's not competent to stand trial, then she's not going to be capable of defending herself. On the flip side, I think that a judge is going to find that she is entitled to opt to defend herself if she's competent. So I think it's sort of two sides of the same coin. Um, I certainly she would not be allowed to represent herself if she's not competent. On the other hand, if she is competent, I think the judge is going to it's going to be difficult for the judge to deny her that right because it is her right. So, good question. Yes, my winter allergies have kicked in, and yes, now that I have moved, I have scheduled time with an allergist, and hopefully get that will hopefully get to the bottom of some of these allergies. Sharon Hutchinson, have you ever been to the Sisters Quilt Show? Girl, have I been to the Sisters Quilt Show. For those of you who are not quilters, the Sisters, Oregon, which is a small town about 20 minutes from Bend in Central Oregon. It's sort of one of the sister communities to Bend. Bend, Redmond, Lapine, Sisters. Um, anyway, Sisters is a charming little town, and about, oh my goodness, probably close to 40 years ago, the quilt shop in Sisters was a very active quilt shop, and they had a very active classes and quilt guild. And so they started putting on a quilt show, and it grew from a few quilts hung around town to every building in town to thousands of quilts. So it takes hundreds of volunteers that come in at 3, 4, 5 o'clock in the morning and hang all the quilts. It happens the weekend after the 4th of July, whatever that Saturday is after the 4th of July weekend. And it is always, thank you, Jennifer. That is the website for Sisters Quilt Shop, Sisters Oregon Quilt Shop. And it is a phenomenal show. And it usually it's summertime, so it's usually hot. If I go, I usually try and go first thing so that we're not walking around in 100-degree weather. It's high desert, so it gets hot and dry. But it is an absolute, thank you. It is an absolute feast for the eyes. Now, what happens during that quilt show weekend is also that Sisters Shop puts on a whole series of classes. So there are incredible teachers coming from all over the country to hold classes the whole week before the quilt show. And people come from all over the country for the Sisters Quilt Show. People make their hotel and their campground reservations a year or two in advance to secure their spots. And all of the hotels in Bend and Redmond and all the surrounding area are always full as well. If you love to quilt or you just love art and color, it is an amazing show to come to. And who knows? By then, I might have quilts in the show. Who knows? I have had sent quilts to the show before, so um, yeah, Sisters Quilt Show is one of the longest surviving quilt shops in the country, let alone in the Northwest. So uh, um, Valerie Wells, who is the daughter of the founder of the quilt show, now runs the show and the shop. She is also a fabric designer. She's an artist and an incredible designer of fabrics. So she she the fabrics she designs are absolutely beautiful, and I always enjoy when I see her. Her patterns are pretty contemporary, but she's a really gifted artist. So that's probably more than you wanted to know about the Sisters Quilt Show. But if you get the opportunity, you should go. Any more questions? I'd love to hear some of your comments on what your thoughts on Delphi. Any thoughts on Young Thug? That turned out to be pretty interesting. Um, I thought it was a little strange that his lawyer, he was offered a plea. And it's kind of interesting because I think there was a little bit of sort of information being telegraphed to the judge sort of by the way that it was done. So one of the things that happened was he was offered a plea, and one of the conditions of his plea was that he couldn't have any contact with anyone else who was convicted of a crime or was on probation or parole. Well, what that means is about half the people who are in her signed to his label would not have been able to record in his studio. So he had contractual obligations with people who were convicted, and some of them who were involved in this case. So he would not take that plea deal because of that. All the rest of the terms of the plea seemed reasonable, but he wouldn't take the plea deal because of that. But that was kind of, plea negotiations typically are not discussed with the court. But in this case, the defense was allowed to bring it up, and they were allowed to say to the court, Mr. Young Thug didn't take the deal because it was in conflict with his contractual agreements with the artists who are signed to his label. That sort of telegraphed to the judge that everybody agreed to the outcome. It was simply a matter of that sticking point. So even though they pled him to open sentencing, meaning that the judge could have given him a lot of time, I think it was like 16 years possibly, it was pretty clear that the judge was going to follow the recommendations the state had made if he had taken their plea. So that's what the judge did. And the judge then fashioned restrictions around his contact with his other people, with his the artists who are signed to his label, without completely forbidding him to have any contact with them. So I thought it was a decent outcome. I don't think either side really wanted to retry the case. The judge had offered them a mistrial, but without prejudice. And if you remember, in the Baldwin case, that judge declared a mistrial with prejudice, meaning those charges could not be refiled. In Young Thug, the judge said, I'll give you a mistrial, but it'll be without prejudice. She was not prepared to go as far as saying the prosecutors have committed enough misconduct that it warrants a mistrial with prejudice. And so, what that would have meant would essentially be that the prosecution could go back and clean up all of the mistakes and all of the ridiculous stuff they did in the first trial. And they essentially would be getting a second bite at the apple. So the defense didn't really want that. But the prosecution was enough in a position where they were able to leverage them into a plea negotiation. And that negotiated plea allowed Thug to go home, to go home on time served. Now, he's still got some other things hanging over his head. He's got a lengthy probation hanging over his head. It's sort of a even before he starts on probation, there's going to be a period where he could be incarcerated and won't be. But all that's hanging over his head if he violates any of the terms of his release and probation. So, every state's a little bit different in their sentencing schemes, but essentially, he got time served for the time that he'd been in jail, and was released and allowed to go home, and on some pretty strict probation and parole kinds of terms. So I think that probably was the best either side could hope for after a year-long trial and another 18 months before to pick a jury. I don't think either one of them were real eager to go back and redo that, even though it would have given the prosecution the opportunity to go back and fix some of their bonehead mistakes. Anybody else have other questions? Thoughts on Delphi is so much reasonable doubt for me. Jane Blackbird, I'm with you. I just think part of it is knowing what I know. Part of it is looking at knowing how unreliable that bullet analysis is. And we've talked about this before. There is a vast difference between a bullet that is fired out of a gun and the imprint that's left both on the projectile and on the cartridge from the firing pin. That is radically different from saying the same extractor cycled this round through this specific gun. And the reason is because extractors don't go through the kind of process that leaves marks on them that turn out to be like a snowflake. Extractors leave marks the same as the extractor in that model gun that was manufactured in that manufacturing plant. That's why even the prosecution's experts said we cannot exclude these other guns. It could be Richard Allen, but it also could be some of the other people who had 40 caliber pistols. So I'm with you. I think that these so-called confessions were coerced out of him, that anyone who is in solitary confinement 23 hours a day with nothing but the Bible and your own thoughts for 13 months is going to lose their minds. It's absolutely inevitable. And that is the reason why both national and state protocols call for people not to be in solitary confinement. It varies from state to state, but the very maximum is 30 days. And even that is considered cruel and unusual punishment. So to keep that man in solitary confinement in a maximum security solitary unit within a maximum security pod is unconscionable. And there's just so many other things that cause concern. Dr. Walla, the prison psychologist who was in charge of treating him after he decompensated, it was discovered was in a whole bunch of online chat rooms. She was obsessed with the case, had been following it and in a bunch of social media chats long before she was tapped to provide treatment for Richard Allen, continued to participate in those chats and to drop information into those chats after she was treating him. And there's no way of knowing whether how much that influenced her perception of what was going on with him, of his statements. There's no real idea that none of her sessions were recorded. She recorded her notes later, so there's no real clear indication that of what exactly Richard Allen said. No way to know his tone. No way to understand his, what his demeanor was. In one case, there was a guard who said that Richard Allen had made confessions to him when he was transporting him to a session with medical staff, and the video of that transport move and of that session shows that Richard Allen was virtually catatonic, that at no point did he ever respond to anything that was said to him. And yet this officer says, oh, well, he confessed to me on the way. And there was no sound in those recordings. So no way to know for sure. So, hi, Polly-O. What will happen next to Richard Allen? Sentencing and then what? Appeals. Yeah. So sentencing will happen. I think it's, I didn't write it down. I think it's the 21st of December. They're waiting for pre-sentencing reports. He's set to be sentenced the 21st of December. And then he will be transferred to prison. And then what? Appeals. Absolutely. No doubt they will file a motion for a new trial. They will cite all of the stuff that went on, the prosecution's discovery violations, the judge's BS rulings, all of those. And undoubtedly, Judge Gull will deny the motion for a new trial, and then they will start the appeal process. I think, if anything, they're going to have a great deal of trouble narrowing down the issues on appeal. I mean, they're going to start with Judge Gull's bias. They're going to start with her denial of their ability to put any third-party culprit information on, evidence on, and go from there. December 20th. Thanks, Jen. Okay, December 20th is his sentencing. I'll put that in my notes so I'll know for sure next time. So yeah, I think that we are looking at endless appeals at this point. And I think the unfortunate part about it is that if the Supreme Court were to find that Richard Allen was not afforded due process and that he is entitled to a new trial, it could be months and years down the road. And in the meantime, he continues to be in prison. There's no question that prison's not particularly a safe place for him, although I have to agree that Richard Allen is certainly not the only person who is in prison for committing crimes that involving children, and that the prison manages to keep other inmates safe under those circumstances. So I think that the prison will be able to keep him safe. And I think that, I really think that there may be a civil suit against the prison for their treatment. I don't know at this point. A lot of it has to do with the individual states and the level of sovereign immunity over for government officials. But my understanding is that the particular prison that Richard Allen was in, the first one, was actually is being shut down because of Eighth Amendment cruel and unusual punishment suits, where the that were found in favor of the defendants. So I don't think it's out of the realm of possibility that there'll be civil suits that will come out of this, civil rights suits, federal civil rights, and federal Eighth Amendment challenges to his treatment. So, yeah, I think that in many ways his guilty verdict is just the beginning. But it's super unfortunate for Richard Allen because he's the one who is going to sit in prison and may be innocent. And that's troubling. So, you know, the Innocence Project is overturning convictions right and left. Hundreds of wrongfully convicted people are being exonerated as a result of Innocence Project's work. And I think we're going to continue to see those organizations attempting to right the ship of justice. I have some questions and some concerns about the conservative shift in our country and how that impacts, starting with the judiciary and with the legislative way that state legislatures are now passing new sentencing statutes and many mandatory sentencing schemes and a lot of. So I have a lot of concern about the pendulum swinging in that conservative direction. Not for the political reasons, but for the criminal justice reasons. And the fact that not only at a federal level are we swinging, the pendulum swinging that way, but it also is swinging that way in a lot of state legislatures. And most law is state law. It's unusual for the federal government to be involved in making law. Law is essentially a function of every state. And so as we're seeing some states move to more conservative makeup in their state legislatures, we're also seeing changes in criminal justice statutes, and we're certainly seeing changes in the appointment of judges. So I have concerns about that, and I have concerns about how that relates to some of the cases that we're seeing, the Karen Reeds and the Delphis and some of the other cases that we're seeing where there's a real question, Sandra Birchmore, where there's a real question about the honesty and the integrity of law enforcement, the integrity of their investigations, and the integrity of the court system when the law is applied to a defendant. So that's my 2 cents on it. I understand that that is not that's not everybody's take, but you know, I spent a long time being a defense attorney, and knowing that my primary function is to protect not only my client's rights, but through protecting my client's rights, to protect all of our rights, and to be that bulwark, to stand in the gap and say, wait, we cannot erode our personal freedoms in this way. So I think only time will tell. Other questions? I think we're right to our 2-hour mark, so we're probably about ready to wrap up. So Jen, are you waving at me? Are you scratching your nose? Okay. Um, Even though Jen isn't on screen, I can see her behind the scenes, and so sometimes when I'm talking, I get her waving her arms because she's got something important to tell me. But other times, it's just see you next time. I want to thank everybody for joining us tonight. Thanks for your patience last week. And please, if you would like to reach out to me, send me, oh, hi, Mac. How much do I think the Delphi trial cost? Well, what we know is the average death penalty case costs about $4 million. Now, they didn't seek the death penalty, so I don't know, but Richard Allen was certainly held a long time. So I would suspect at least a couple $1 million. Remember that there were times that Judge Gull disapproved and would not fund the defense's requests for state funds to fund experts. So I think there's some real problems there as well. That may be an appellate issue. And there were times when they actually crowdfunded money to pay experts for Richard Allen's defense. So I would say probably in the $2 million range. There were a lot of phone extractions, a lot of technical um, uh, experts and scientific experts. So it wouldn't surprise me. Great questions tonight, everybody. I always appreciate getting together with you. I know that there are a lot of other things you could do on a Wednesday night, so thanks for joining us. Thanks for your continued support. I appreciate tonight's super chat. Thank you for continuing to support us in our mission. If you really want to support, buy the book. Please, if you have read the book, please post a review. Those are things that help us a great deal. If you are going to be in the Tucson area in March, please come see me at the Tucson Festival of Books. And we will let you know about other places that I might be. We're still trying to set up some time for the week of Valentine's Day in Phoenix. So we'll let you know. And as time goes on, we'll try and get out to visit and meet as many of you as we can. So I'm going to say good night. Have a great week. And we will see you next week for more true crime.